All right. Well, thanks again to everybody for joining. I know we're all busy. I know a lot of us are tired of Zoom, but I guess our hook was good enough to get some people here because we're seeing a lot of stuff right now. It's been a tough year, and a lot of businesses, have. If you're like us, you've been running around so much that you only have so much you can think of. So we wanted to give you 5 tips or 5 things that you can do, you can implement today that they could be some shortcuts to legal protections. And um, we see these types of issues every day. We see them hurt businesses. We help businesses avoid them all the time. So I hope you get something out of this. So before we start, I imagine most of you have been on Zoom, but just a little orientation. Zoom has a chat feature, which we like to use. Everybody is muted to start. You can unmute yourself, but if you can use chat, it'll allow us to ask questions and make sure that everybody gets a chance. We get a chance to respond to everyone. If we don't get to your question today, we'll follow up by email. Turn your camera on if you like. One of the reasons we chose to do this format rather than a webinar in Zoom, which just allows us to push content at you, is we want to see folks. There's some faces on here that we haven't seen for a long time, and I'd like to wave at you if you're there, and I'm sure Meredith would too. Feel free to share stuff about you in the chat. One of the benefits of this could be some networking. If you let us know what you do, who you work for, anything you want to share. And then give it some feedback. We're going to send out a survey afterwards. So answer it, let us know, help us improve. This is the first webinar we've done in a long time and in this format, so always looking to get better. So for those of you who haven't been, this is our office. We're at 2525 First Avenue South, just in the Grand Central District in St. Pete. Meredith, why don't you go ahead and introduce yourself first, and I'll go second.
Yeah, sure. So I'm Meredith Gauntz. Andy and I practice together. We've been practicing for about 15 years. We opened our law firm 5 years ago. It'll be 5 years next month, to represent and support local businesses. So that's why our office is not a big high rise in the middle of downtown. We really want an inviting place for local business owners to come and talk about contracts and employment agreements and handbooks and all of the stuff that business owners love talking about. So we thought it would be less painful if it was in a really inviting, cozy environment. So we love our office. We have an office dog. We call her our para-beagle because she's a beagle, and her name is Penny. I apologize in advance if she snores. And yeah, so I focus mostly on employment law for the business. So anything from we're hiring employees, we're hiring contractors, what's the difference between the two, to I really want to figure out how to protect my information. I'm worried my employees are going to start competitive businesses, to I have an issue, this employee feels discriminated against, or they are fill in the blank protected category, a female, over 40, disabled, any of those things. And I need help writing them up or performance managing them or those kinds of things. And so we're kind of like a back office HR team for, if you don't have an internal HR support.
And while local business is our passion, I grew up in a small town in Kentucky. My family were all entrepreneurs. Meredith from Savannah, her family, a lot of entrepreneurs up and down the Eastern Seaboard. We found that because of what we do, we attract clients from all over the U.S. and clients based in Tampa Bay, that recognize that we've got a pretty sophisticated experience for a two-person law firm and provide a level of customer service that you don't get from a lot of law firms, to be honest with you. I do business law, so a lot of what I do is the day-to-day stuff that if you're a business owner, you're dealing with. I just got a big contract that's going to be huge to my company. I want a lawyer to take a look at it, or I'm expanding into a new business line. I'm not sure how to structure my business, or I have an opportunity to buy or sell a business or take on an investor. How do I do that? What are the market terms? What do I need to look out for, and what do I need to avoid? But we're not just lawyers. We do a lot of other stuff. We're very involved in St. Pete. We've been here for 12 years. I guess the newest tidbit is Meredith published a traveling book, or pardon me, a travel book for St. Pete with a good friend of ours, Melanie Bowman. It's available at Tumbolo Books. It's available at Book and Bottle locally. So if you haven't checked out those shops, please do so. They're great assets to the community. Also, it's available on Amazon for those of you who are outside of the area. And also, some of the retailers are carrying it. So Plain Jane in the 600 block of Central. Meredith's also a jewelry maker. She has an Etsy shop. Her jewelry sold on the pier. If you've walked up to the pier from downtown in St. Pete, you'll see some vendor booths. The Craftsman House has a booth where Meredith's jewelry's sold, also available on Etsy. And for me, we're very passionate about animals. I've also got a black lab laying next to me. Meredith's got a parabeagle. So I serve on the board of the SPCA Tampa Bay, which is we're huge supporters of that. And I like music. One of the best things about this pandemic is a buddy of mine started playing banjo. I've played guitar forever, and every Tuesday night we get together in the backyard and invite folks from the neighborhood who enjoy music to come over and play. It's a very wholesome and fulfilling hobby. So enough about us. We're going to go through actually 6 tips today. Some of them are going to be applicable to all businesses. Some will focus on smaller, some will focus on larger. Again, ask questions through the chat as we go. The first thing I wanted to talk about is there is no free lunch. When it comes to limited liability, a lot of folks think that forming an LLC, forming a corporation on SunBiz and paying your $125 gives you this bulletproof vest against lawsuits. So let's start with a little overview of what limited liability is. This is going to be really high level for a lot of you guys. Excuse me, So we all have assets that we own, our personal assets, our checking account, our dogs, our games, our homes, our technology. If you're operating a business, you've also got stuff that you use at work. If you don't have any type of entity protection, then everything you own, business and personal, is at risk. And when I say at risk, from a car accident, from a lawsuit from a customer or a client. Let's say that you own a spa and somebody comes in and they get injured while getting their nails done. If you haven't set up if you haven't set up a company, you should do that now. I think a lot of people are doing this, but a lot of people also are setting up side hustles it's happened over the last year, and a lot of people are leaving their jobs to pursue these side hustles. You got to get a little more formal. And the benefit of getting a little more formal is that you can separate out your life and your business. You can take the risk by putting your $50,000 into a business, your $5 million into a business without risking your house, without risking your kids' college funds. So when I talk about limited liability, that's what I'm talking about, is separating out your personal and your business life from legal risk. So one of the things we promise you today is practical information you could go home with and implement today in your business. So the first thing, if you want limited liability, you got to do more than form a corporation. You have to act like a business. You need to have contracts with every customer, every transaction. So if you're a web-based business, that may just be your terms and conditions and the box that your customers click on when they check out. For service businesses, for those of you who are our clients, before we work with you, you get an engagement agreement. When we work with marketing firms, we expect to get a services agreement for them. If you want limited liability, having a contract in place is going to be one of the best protections you can get. Segregating assets and expenses, I think, is more important than anything. It's really tempting to pull out the credit card when I'm at Publix buying Spindrift and put it on the business card because I know I'm going to save some taxes on that. If you do that, your bulletproof vest of a corporation is going to get chipped away with every formality that you fail to follow and every expense that goes in there. And what that means is that separation between your business and personal life starts to disappear. If you're a larger company and you're setting up verticals for either subsidiaries or verticals for different product lines. So for instance, Patagonia they just bought Osprey's backpack line and they're operating it as a separate company. there's a lot of formality you should have in place there. If you're sharing employees, if you're sharing back office, you need to have some contracts in place and some structure in place to make sure that if a backpack blows up, you don't lose your clothing line. Maintaining reasonable but not excessive cash reserves. Don't take money out of your accounts if you can't pay your bills. Pretty basic. The law views that as stealing from whomever you're supposed to be paying. But don't keep excessive money in your business checking account. So many people do this. We were guilty of this at first, where we knew that we needed X $1,000 to pay for 2 months of expenses, and we kept 10 times that in our business checking account. That's our money. We are an LLC taxed as an S corp, so we pay taxes on the money no matter what account it's sitting in. But by keeping that money in the business account, it's subject to all of your business risk. Whereas if you take it and put it in your personal account, that you're much more likely to get that limited liability protection. So for example, if you're in your business automobile and you get a wreck and you have $200,000 sitting in your company account that you've been saving to buy a vacation home, well, that's now going to be given to this car wreck victim as part of the settlement. Whereas if it was in your personal account, you'd be much more likely to have your insurance maxes kick in and maybe not have to come out of pocket. And finally, follow the formalities. If you set up a company, there's certain things that you need to act like a company from a legal perspective. So keep records, file your tax returns, document things such as your investments coming in, people exiting the business. There's a lot of paperwork that comes with running an entity, but it's a cost of doing business. It's not an option if you want to get limited liability protection.
All right, well, I'm going to take this one. So if you remember nothing else from me today, remember that you need to hire slowly and fire quickly. What does that mean? It means that when you are bringing someone into your company, into your fold, you really need to make sure that it's the right fit, not only for a morale reason, to make sure that they work well with your team, to make sure they can do the job, but also from an avoidance of claims of negligent hiring, potentially not vetting them appropriately, potentially not doing background checks. All of those things can fall back on the company because sort of as employers, we kind of own the mistakes of our employees. So once you bring someone onto your team, you really need to make sure that they're going to be a good representation of you, of your business. They're going to be able to do the job. I get the question all the time, but, aren't we in an at-will state? Like, can't I just fire them if it doesn't work out? And I think that's a common misperception because we are in an at-will state. Florida's an at-will state. What that means is you can let an employee go at any time for any reason, with or without cause. But the burden, this is the big but here, the burden is on the employer to prove that the reason wasn't illegal. So what that means is in reality, the employee who you let go because they just weren't a good fit, if you don't have really documentation leading up to that termination, that employee is going to often do what I call throwing spaghetti at the wall. And so they're going to think, well, I'm sure it's because I'm a woman, or it's because I told my employer I was pregnant, or it's because I have this disability, or I'm in a minority, or any of those protected reasons. And so then the burden shifts to the company, to us, to say, no, the real reason was blah, blah, blah. Whether it was, you kept screwing this up, or your performance wasn't good, or you made people uncomfortable, or any of those things. And all of those things need to be documented. So it's really important that you make sure that the person's a good fit before you bring them in, because it's not as easy to get rid of an employee as some people think it is. So that's something to keep in mind. The other thing that is critical too is once someone is in your fold, once they're in your business, they're going to be privy to your company secrets, to your clients, to your employees, to your practices. And so, all of that, and I'm sure, for many small business owners, I mean, our business is our baby. And so you really want to be sure that when you bring someone in that they're going to be a good fit. When you see the writing on the wall, when you see that an employee isn't working out or isn't a good fit, it's important that you address it. You address it in a timely manner, you address it in writing, you let them know what is not okay, and you kind of set that process in motion. And I'm not a stickler for it has to be on this super formal template that says warning in all red caps at the top. We did a social media post a while ago where, Sarah Jessica Parker, breaks up with the guy on the Post-it in Sex and the City. And I mean, it can literally be on a Post-it if that's, the documentation you have, as long as the employee knows what they can't, what is not okay, and what the consequences are for continuing to do that thing. And then they acknowledge that they got it. So I think it's really important to make sure that you're addressing those things. A big part of that is because employees see the writing on the wall. So oftentimes what will happen is an employee will say, oh gosh, well, I can tell that they don't think I'm doing a good job. Before they write me up, I'm going to file a workers' comp claim, or I'm going to raise a claim of harassment, or I'm going to do any of these things, so that then when you do write them up, it looks like retaliation for them raising that concern. And retaliation is actually the most common claim we see as employment defense attorneys come in through the EEOC. So, and it's really hard, on a timeline to say, well, why didn't you write that person up before they complained about their injury or this issue? So it's really important to address things in real time. So the key takeaways for kind of the slow to hire, quick to fire, make sure that your interview questionnaire is thorough, make sure it's based on the specific job description so you're getting a really good fit, and take a look at your onboarding documents to make sure that if you're doing a background check, you're doing it right, and you really are thinking through these things before you bring someone into your world. This is Penny standing in the doorway of our work world. And also just kind of, if there are employees that you've been putting off, dealing with or disciplining or kind of addressing performance issues, start doing it, because the chances are they know that something is coming, and you want to be sure that you kind of start that dialogue with them sooner rather than later.
One of the things that makes Meredith and I work together so well is that we feel our clients' pain. When somebody comes to us, and it happens all the time, and says, this person's been messing up forever, at the last minute, they quote unquote blew the whistle on this minor issue in the office. That was the last straw. And then when we talk to them and we see that there's no documentation, and we have to share with them that a lot of that stuff that you've talked to your employee about, you might have to act like it doesn't happen. So when we hear those stories, we come home at night and we cringe and we empathize and say, I feel so bad for that for that company, because this could have been avoided, and we focus on helping them avoid the future issue. So next time this happens, these are the 6 things you need to do, and if these 2 things happen, you need to call us before you do anything. So creating an ownership agreement. So some of you guys might have business partners. A lot of you may not have business partners. But when I talk about an ownership agreement, this is you may have heard the terms partnership agreement, shareholders agreement, operating agreement. It's really a plan for the future. It's beginning your business with the end in mind, because exiting a business partnership is, legally speaking, more difficult to exit than a marriage. Getting divorced, there's a playbook for that. There's a lot of emotion, there's a lot of tension, but there are rules around. This is how you calculate alimony. This is how you split assets, et cetera, et cetera. The rules for business divorces they're vague, they're a mess. It's a one-size-fits-all approach that works for nobody. And the way that you get around the pain and the suffering that comes when, the example I use is, what if your partner has an eat, pray, love moment and wants to move to India and become a monk? How do you deal with that? Because this is the person that's been sitting by your side, or the people that have been sitting by your side for a long time, emotional support, doing taxes, whatever they have been doing. You're going to have to replace them. What does that look like for the company? Are you going to have to buy them out? If you do, where are you going to get that money for? How much are you going to pay them? What if they're still around and they're just not doing their job? There is not a easy solution under the law for any of those scenarios. Unfortunately, a lot of time, if you don't have this foundational document, an ownership agreement, and it gets so bad that you can't continue to be in business together after you go through a lot of the pain and the feelings of betrayal from your partner, a judge will end up deciding what happens to your business. And this is a judge that 4 weeks a year, here's family law cases. 4 weeks a year, here's criminal law cases. 4 weeks a year, may deal with elder law cases. They're not business experts, and they're so overburdened that they can't take the time to really understand the nuances of your business, of your baby. So they're going to split things down the middle. They're going to come up with a result that doesn't work for anybody very well. So beginning any type of partnership with the end in mind is extremely important, and probably one of the best places you can spend your money. When we meet with new clients, we always ask, what's your legal budget? And oftentimes those legal budgets are a line item, that a do not exceed line item, and the needs far exceed the amount of money they have to spend. So one approach Meredith and I take is to prioritize this. We sit back and said, well, if I had this amount of money to spend on legal needs, I would focus on, this is the order I would focus on them, and this is the timeline I would try to do it. Obviously, if somebody comes to us with a major issue, we've got to deal with that first. But what we really love to do, and where we have had the most success, is helping people avoid those company killer issues that result in 40 grand in legal fees and hours and hours and hours away from your business. So when I'm talking about ownership agreements, we talked about limited liability. Ownership agreements protect solopreneurs too. So we talked about a few things: that you need to have enough cash. One thing I didn't mention is you need to have adequate insurance. An ownership agreement for a solopreneur, you're the only person in your business, you have an LLC, can provide you some protections as well. It's much simpler, but there's some things you can put in that ownership agreement to protect against your creditors, perhaps taking some of your assets if you were to get into trouble down the road. If you're going into a partnership, an ownership agreement covers these major things: protecting you from creditors, potentially helping you preserve that limited liability, figuring out how you make decisions. What happens when you want to buy another building, you want to expand, you want to limit your business? How do you make those decisions? So many of the businesses we see are 50-50, because at the beginning, I think we're all inclined, a lot of us are inclined to be equitable with our friends, families, and business partners and say, we're going to put in the same amount from the beginning. Let's split the decision-making 50-50. We're always going to agree. That is fraught with the issues that you can imagine. If you're butting heads, you can't agree. So putting in provisions in an ownership agreement up front for cutting that off and making it less painful, there's not that many approaches, and they're pretty simple to put in place. And one of the things we like to do with clients is talk through, all right, here are the 16 or the 6 choices for how you could deal with it. Let's game out some scenarios of what could happen in your business and what the outcome would look like under that, and then help people get to the right thing for them from a practical, from an emotional, and from a legal perspective. Profit sharing. How are you going to split the cash? Pretty simple. Are you gonna, if somebody puts in extra money, are they going to get more out first, or is that just going to be on the back end when you sell the business? I'll tell you, the default rules again for these types of questions are not clear and are not right for a lot of businesses. And then exiting the business. When I talk about a marriage being easier to exit than a business, you can file for divorce and it starts a clock going, and it starts a process that's pretty well defined. There is no document that you can go and file to divorce your business partner. It does not exist. So building out processes for figuring out how you're going to exit the business. When good things happen, you get a huge offer for $10 million for your business. And when bad things happen, your partner stops carrying his or her water. That's a huge part of an ownership agreement. So if you don't have an ownership agreement and you have partners today, sit down with them. I've got a list of things that you should talk about with your partner. Happy to share it with you if you want to start that conversation. It's not a comfortable conversation, I'll tell you. You've got to talk about a lot of things. It's kind of like forming a will. What happens? Meredith and I did that not so long ago, and the question, what happens if both of you die at the same time? Not a fun thing to think about, but practically speaking, it's a good idea.
So a big part of what we do is we defend employers whenever they get a charge of discrimination, which is the first step in filing an employment-based lawsuit, has to go through the EEOC. And the very first thing the EEOC usually asks for when you're putting together your response to basically explain, no, we didn't fire this person because they are a woman, African-American, disabled, whatever the protected category is, we actually fired them because of performance issues or conduct issues or those kinds of things. The first thing they ask is, do you have an employee handbook? If so, let's see it, and let's see that the employee acknowledged it. And so, a lot of times companies will say, well, I don't need a handbook. There are only 5 of us here, or there are only 7 of us here, or whatever it is. And a lot of employment laws kick in, actually local regulations, which are basically, they require the same things that the federal and state laws do. They kick in when you have 5 employees here in Pinellas County and Hillsborough County, and a lot of counties across the state. So you really do need to make sure that you have policies against discrimination, harassment, retaliation, all of those things are included in your employee handbook. And some companies opt for a really robust handbook, 30, 40 plus pages. They want to put a lot of specifics in them. I think if you have nothing and you have no handbook right now and you do have employees, I would say having, an equal employment policy, a no discrimination policy, no harassment, and no retaliation is probably right up there with the most important things that need to be in there. Another thing is your at-will policy, which basically just says what we talked about before, that this is at-will employment. You're not guaranteed employment for any particular period of time. It's important that that is stated clearly in your handbook. Another thing, probably a really common issue that we see is with regard to unemployment. And so in Florida, employees who are terminated for performance issues are eligible for unemployment. And this past year, unemployment has been just crazy. But, and so, a lot of what we've expected in the past have gone out the window. But sorry, I'm letting people in the waiting room. If an employee is let go for misconduct, though, and so this is where the handbook is going to come in, because what is misconduct? How does your company define misconduct? So if they're let go for misconduct and they've been disciplined for it, they're aware of the requirements, they're aware of what's allowed at work, and they still do it, oftentimes, and it does depend on the investigator, but usually they shouldn't be eligible for unemployment because misconduct is different from performance issues. So one of the things that we do when we take a look at someone's handbook is we see how they have defined misconduct. What are your performance expectations? What do you say is misconduct? For example, a lot of handbooks will include attendance issues in performance stuff, where I would call it misconduct. So if you have someone who is a no-call, no-show for multiple days or is repeatedly late, you want to be sure that that is considered misconduct by your company. And when you write them up, you tell them this is considered misconduct, so that when they are let go, it is for misconduct and not for poor performance. And that's going to increase the likelihood that you, as the employer, will not have to pay, or your account will not have to pay them their unemployment. Unemployment sort of, I think of it like an insurance policy. So you're paying into it for every employee you have, and usually don't have to come out of pocket if an employee is awarded unemployment pay. But it potentially will increase your premium the next year because now the Department of Economic Opportunity has paid a claim out of your bucket. So that's usually the way that I think about it, is you're kind of putting into this pot. And I've been getting a lot of questions about rates, unemployment rates this year. Just wanted to touch on that because, more unemployment claims were paid out over the last year than I think certainly ever in my career and many, many years. And so, I think naturally as employers, we all kind of expected that our rates would go up. And so they have. I've been getting a lot of questions. I didn't pay any claims. I don't know why my rate went up. I think we all kind of expected that would happen because we need to fill that pool again. So I just kind of wanted to make sure everyone was aware of that. So I thought this was funny. I love this Indian Hills Community Center. I don't know if you guys follow them on social media, but they have some really hilarious memes and puns, and puns are like my love language. So I think actual notes do work better than mental notes. So it's important to have things written down when it's important to your business. I would start creating a handbook if you don't have one. And it can be kind of those key policies, and you can just build on it. It's less overwhelming if you do things gradually, I think. So when we first opened our firm, for example, it was just me. I opened the firm about a year before Andy joined, and I started putting together a procedure manual. And it was literally a Word document, because I'm not the most tech savvy person, and had, a paragraph in it. And then, now I think it's like 13 or 14 pages because we kind of have updated it as we go, and it makes it less overwhelming. Make sure your handbook is not really worth anything unless your employees sign it. So make sure you've shared it with your employees and you have acknowledgments for all of them. And then here are some of the key things that I really like to see in a good handbook: policies against discrimination, harassment. Make sure you have the at-will employment language and those conduct expectations we talked about. This is just kind of very near and dear to my heart right now because we represent a restaurant chain, and they actually have 2 race discrimination charges pending against them. So I'm working on their position statements right now. They're due next week. And unfortunately, neither of the employees received or signed handbook acknowledgments. So it certainly puts us at a disadvantage in proving to the EEOC that we have this no discrimination policy. These employees knew that. They could have complained about it if they felt mistreated. We have no way of proving that they knew any of those things. So it certainly would make things easier. Hopefully these claims will never happen against your companies, but just in the event that they do, it really, really is helpful to have these in your arsenal.
So we mentioned earlier that Meredith focuses on employment and I focus on business law. We've cross-trained each other. We obviously talk a lot. We live together, we work together, and we enjoy what we do, and we care about the people we work for. So we've done some cross-training. And when I think about employment law, what comes to mind is common sense isn't that common, and there's no common sense legal defense. So you or I as an employer may think, well, of course, XYZ employee knew that I would dock their pay if they didn't give me my laptop back at the end of the day. But believe it or not, it is you can't just do that unless you've given some advance notice to the employee. I mean, it's ridiculous. I'll tell you right now, it is ridiculous. But, the law is written broadly and unfortunately doesn't address all situations well. When I think about handbooks, I got pulled over. I was on my way to an SBCA Tampa Bay meeting that was at 8 a.m. and got out of the house late, and I got pulled over and I didn't have my license and registration with me. So I got written up. I got a ticket. I had to go down to the courthouse and provide that documentation. I think I ended up having to take a course so I didn't get points. To me, the handbook, when you get into an issue with unemployment or the EEOC, that's like your license and registration. If you don't have it, it's going to be a whole lot more painful and expensive to deal with those issues.
So this is an area that where a lot of questions come from regarding employment issues. And this is kind of, how do we pay people? I mean, that's a very important part of their job, a very important part of your job as an employer. How are you going to pay them? So one thing to understand is knowing which employees are exempt and non-exempt. A lot of times I hear that exempt means salaried employee and non-exempt means hourly. And that's not true. So those terms are often used interchangeably, but they're not interchangeable. An exempt employee is someone who doesn't have to track their time, and so they're not eligible for overtime. And overtime is time and a half for over 40 hours of work in a work week. But in order to be exempt, you have to be paid a certain salary. So that part's true, but you also have to fall under one of the exemption categories. And so an employee can't say, look, I don't really want to track my time. I don't really care about overtime. Can you just pay me this salary and let's just go from there? The employee doesn't get to pick that. And if they do, and it ends up backfiring, it's going to backfire on the company, not the employee, because employees cannot waive their rights to overtime payment, and they cannot waive the obligations that the employer has to track their time. So one of the key things is making sure that people are properly exempt. And I would say the most common claims I see are related to employees who are misclassified as exempt. So the employer isn't tracking their time, they have no time records, and then the employee, either through their own initiative or through the Department of Labor, or sometimes I've seen these come in a roundabout way through the IRS, will say, look, we need these time records and we need to, make sure that this employee didn't work any overtime. And when you don't have them, it is near impossible to recreate accurate time records. And the burden is on the employer to prove that the employee didn't work. And so what often happens, and why these claims are like the bane of my existence, is, often these are not intentional mistakes by the employer. Some of you may have seen the video that we posted on Facebook, kind of talking about one of the things that a common mistake we see. And one of them is, employers will have employees put on their timesheet, 9 to 5, 9 to 5, 9 to 5. And the employer's thinking, well, I'm actually doing them a service because they actually take a lunch break, but I don't require them to clock out for that. Or they often leave early, but I don't require them to clock out for that. You have now undermined the accuracy of your time records. So there are ways to help your employees, to give bonuses, to pay them for additional time if you want to, give them PTO. There are other things you can do that aren't going to compromise the company from a legal perspective. Because when these claims are filed, that an employee wasn't properly classified or timekeeping wasn't done appropriately, a lot of times those become what you hear of as class actions, because the employees will then band together and say, look, a bunch of us weren't paid this same way. These are all inaccurate. And because of that, you now owe us our wages, you owe penalties, and you also owe us our attorney's fees. So good question, Elizabeth. Exemptions. There are a number of categories, and they're listed. The Department of Labor has a really good fact sheet that talks through all of them. The most common ones are called administrative and managerial. And there's also one that's pretty common for outside sales professionals. And so in order to fall under one of these categories, you have to either make key decisions for the business. And that doesn't mean what kind of paper do we order. They have to be like key decisions. I've had, clients who try to fit employees in these exemptions, and they don't really, it's like a square peg round hole. And so and then also the managerial exemption is managing 2 or more employees. But in order to do that, you really have to have the authority to hire, to fire. It's not just, I check them in and then basically we all work on the line together. So it's important that you're actually doing the exempt duties. Interestingly, there are ways to have a non-exempt employee, someone who doesn't fall under one of the exemptions, but you really want to pay them a salary. You can have someone who is salaried non-exempt, which can blow some people's minds that it's possible to do that. But just, it's important that if you do have someone who you are treating as exempt, you're not tracking their time, you're not requiring timesheets from them, they really fall under one of those exemption categories, because this is a really common kind of area where I see people make mistakes. The other one is independent contractors versus employees. And this is something we probably get questions about, I don't know, Andy, like maybe every week, if not twice a week. And so I think of these kind of classification issues as like a bomb to your company. So this is Rudy, and this is a drool bomb. And so this is my visual. I want you to think about this drool bomb like all over your computer screen. And like, so we need to avoid that at all costs. And isn't he so cute? So he's 10. And so, yeah, so it's really important that when you're classifying independent contractors and employees that you're doing it properly. I just had recently a question come up that someone was classifying an independent contractor working for them, but they were really supervising a lot of their work. They actually had to sign off that, you know, that person needed supervision hours, this independent contractor, which by its very nature means that that person is not independently operating. So when you do have an independent contractor, someone who you're paying with a 1099, not with a W-2, it's important that you, A, have an independent contractor agreement with them that clearly says, you will not get a W-2 at the end of the year. You will receive a 1099. You are responsible for paying the taxes. I mean, it can be just totally clear. It has to be totally clear about what happens, you know, with insurance. Or they're not eligible for unemployment. They're not eligible for workers' compensation. All of that needs to be spelled out. And then in practice, you need to do all of those things. You need to really have them be independent. Otherwise, they're really an employee, and you need to W-2 them and reclassify them. So I would say my homework, my action items that I'm giving to you are make a list of your employees and whether you're treating them as exempt or not exempt. If you're not tracking their time, you're treating them as exempt, and pull up the Department of Labor site, search for DOL exemptions, and it'll tell you which ones are available, and see if they fall under one of those. I love having spreadsheets. I would put a spreadsheet of the employee, whether they're exempt, non-exempt, and if they're exempt, what category? Are they managerial? Are they outside sales? Are they a computer professional? Which one do they fall under? And if, God forbid, you ever have a Department of Labor audit who questions your classifications, you then have that ready to go. You know, no, they're exempt because they're in this category. So that's really important. And then with your independent contractors, make sure that if you do have independent contractors, you have signed agreements with them. You have W-9s from them instead of a W-4. W-4 is the tax withholding document you get for your employees, your W-2 employees. So you don't want one of those if you have a contractor. Contractors fill out a W-9 and then you pay them with a 1099. So just maybe take a look at that, make sure that you don't need to revisit any of those.
One place we really want to caution you on is putting your future in your payroll company's hands. A lot of payroll companies now a lot of our clients go to their payroll companies and ask questions, ADP, Paychecks, those type of companies. These are companies that if you have employees, you don't want to calculate taxes, you don't want to have to handle giving them a check every 2 weeks, so you outsource it to a payroll company. And as a kind of an upsell or a benefit to you joining them, they'll say, you know, we will have a hotline that you can call to ask these types of questions about independent contractors and salaried employees. Keep in mind that if they get it wrong, your recourse against them is essentially to cancel your contract and maybe get a couple of months pay back. You know, Gusto, I think right now is asking $49 a month to do your payroll, $49 an employee. So an issue like this is going to, you know, I talked to another lawyer recently. She said, for some reason, all of these issues end up at $12,500 in legal fees. You're going to get $150 back from Gusto if they get it wrong. So I kind of liken it to if I had a plumber come in the house and she offered to fix my electrical problem, I would look at her like she's crazy. You need to take the same kind of skepticism with payroll companies. Go to the source. Department of Labor has some great resources. Another great resource is SHRM, SHRM. It's kind of the leading trade association for the HR industry, and they can have some great articles that will point you in a good direction. And then call us if it's confusing and you don't get a straight answer. You know, we have all kinds of 15, 30-minute conversations with potential new clients where we're able to help them solve their issues over the phone. And you know, we love to help. So give us a call. We'll tell you whether it's a an issue you need to deal with immediately, if it's something we can handle over the phone. Just one more thing on this is we deal with a lot of startups, and startups don't have a lot of cash. So I hear them often saying, I don't have enough money to pay the salary for a chief technology officer, so I'm just going to make her an independent contractor. If there's one take home that I like to give them is, it's not your choice. You don't just get to call somebody an independent contractor. On the flip side is, this person's working 80 hours a week to save money, I'm going to pay her a salary. Can't do that either.
Yep.
So we're looking at about 12 minutes left. Are there any unanswered questions that we need to address, Meredith? No?
I don't think so. Nope.
Okay. So the last thing we wanted to talk about is protecting your stuff. And by stuff, we mean your brand, your information. We're a service company. So that is our business. We don't have a lot of inventory. We don't have inventory sitting on the shelf. We don't have cars on the lot that are going to make us money in the future. What we have is our brains and our intellectual property and our brand as Law. That's where our value is. And we've had, in the past, we've had some intellectual property issues with other companies, and learned a few lessons. Unfortunately, another law firm in town recently had to change their name because they got a nasty letter from somebody in, I think it was North Carolina, saying, you're using our name. You're also, your entire advertising, they said, defames the legal profession, and we want you to stop. This person had invested years, and it was a great brand, and she had to change because somebody got it first. So Meredith's going to talk to you a little bit about how you do this with employees. But when it comes to brand protection, a lot of companies, your brand is your name. You know, Sephora, Pepsi, Coke, Apple. That is, that's what you're selling. You've built up a reputation with that. If you're at the start, don't pick a name without figuring out whether somebody else is already using it. It's a pretty simple step, but people skip it all the time. If you've invested money in your intellectual property, in your name, in your brand, keep an eye out for folks that may be using the same name. We had a client recently who set up an Etsy shop to sell a pretty cool product related to whiskey. And 2 weeks later, he got an email from somebody else on Etsy saying, hey, that product that you're calling super awesome product, we've been advertising this product on Etsy for 6 months, and you need to stop using it because it's ours. I mean, luckily for this client, they had not branded all of the inventory, hadn't invested a lot of money, but that afternoon that he called me, he was going to do a pretty expensive product and shoot and video that was going to feature that name all over it. So we were able to help him avoid spending $7,500 on something that was going to have to be reshot earlier. You also need to protect customers, consultants, people outside of your business are a huge risk for your intellectual property. We had another client that invented a product, took it to a company to create a prototype. The company, asked a lot of questions, did a lot of development for them, and then eventually said, no, we can't do this, we're too busy. And then 6 months later, they've developed the same exact product pretty much, or at least a product based on my client's prototype, our client's prototype. And unfortunately for this client, they didn't have an agreement in place that had the right confidentiality protections that would have put them on a really good footing to go after this company. So kind of like not having your license and registration, not having that contract meant that he was almost fighting with one hand tied behind his back. So if you're sharing your intellectual property with anyone, we have clients that use service providers, and in order to use those service providers, it's somebody coming in to tell you how to save money. It's a business coach. It's the janitor that services your 5,000 warehouses. The janitor is going to see a lot of stuff inside your business. You're probably going to share some information with your service providers that you don't want getting out into the world. Have a contract, as we talked earlier, and make sure that in there you mention that, hey, I might share with you stuff that I don't want you to share with others. And if you do that, then there's going to be penalties for it. So if you have contracts, go ahead and have confidentiality agreements in them. If you're doing joint ventures, if you're partnering up with a customer, it's a huge issue of what you're going to share, when you're going to share it, and how you're going to share it. Talk to a lawyer in that instance because it can get pretty complex. We can put legal protections that'll help you on the back end, but the best practical protection is only share things that potentially could be lost. And when you're sharing things that are super valuable to your company, there are many products out there that will allow you to share it in a way that is traceable, trackable, so you can know where it went and when. Emailing out confidential information is a really bad practice. It's like emailing somebody that asks for your Netflix password. Here's my username and password, when hackers out there are monitoring your email and looking for the word password so they can go and steal it. Same thing with confidential information. Once it's gone out the door in email, it can be distributed anywhere very simply. So stop that practice. Go find a secure file transfer. And then we talked about monitoring and enforcing. If you see somebody using your brand, you've got to take steps to stop them, or they may, over time, get the ability to use your brand and you might not have an objection. So if you see something, say something to them.
The other side of kind of protecting your information is with regard to your employees. Like we were talking about earlier, once you let someone into your fold, they're going to be privy to a lot of information. I mean, for example, we were representing a soap company, and they spent years perfecting this soap recipe and all of the scents and everything. And they wanted to be sure that anybody who was coming in to help make and sell this soap wasn't going to potentially sell their recipe or use it to start a competing business. And so we draft a lot of, we call them business protection agreements, because really that's what they are, but you may hear of them as restrictive covenants, non-competes, non-solicitation agreements. Interestingly, in Florida, and maybe it's only interesting because I'm a dorky lawyer, but interestingly, in Florida, you can actually enforce non-compete agreements against an independent contractor, which is kind of strange and something that you probably want to think through. But I'm definitely partial to having non-solicitation agreements and really robust confidentiality provisions, because that's really the concern. Because if somebody opens a competing business down the street, obviously there are certain industries where you would want to prohibit them from doing that. For example, hairdressers. You really want to kind of consider your radius. A lot of businesses are online now, so non-competes are not as relevant. I think it's really more, don't take my people, don't take my employees that I've trained, don't take my contractors, don't take my customers, don't take my lists, don't share any of my stuff. And so as long as it is reasonable in time, it can't be a 10-year non-solicitation, or 5 years is actually probably a little bit too much. Usually what we see is more like 1 to 2 years. But as long as it's reasonable in time, it's reasonable in scope, and it's going to protect your business interests, it's going to be enforced in Florida. And actually, Florida is the most employer friendly. This is like the best news that you'll hear all day. The most employer friendly when it comes to enforcing restrictive covenants, business protection agreements, than any state in the country. Some states don't even allow you to have these kinds of restrictions because they think they're a restraint on trade. So they're saying, like, for example, in California, you can't say you can't open a, employee A, when you leave here, you can't, take my customers and open a competing venture down the street. They can do it. You can't prevent them from doing that. But it is important that these are well-written, tailored to your business. I get a little bit concerned when people, find them on LegalZoom or something like that, and they're not really, the confidential information doesn't make sense for their business. So you really want to be sure that what you're protecting is what you really want to protect. If it's your customer list, you make sure that it says customer list, customer data, customer contact information. You make sure that it is clear as day that that is your confidential information. I think it's important to, and then if you have an independent contractor agreement, you can put these restrictions in there, while you are, a contractor for a company, and for X period of time after you leave, you can't solicit our people. You can't take our customers, you can't take our clients, you can't take our employees. So you can do that in the independent contractor context too. And that's a good a good venue to do that, to set out those terms. So, but I would say this is something that you definitely want to consider with, I can't think of an industry where you wouldn't want to safeguard your information.
One quick follow-up, getting the website name and getting the corporation name gives you virtually no protection. So if you've got a valuable name, if it's Cakes by Linda, there's not much you can do to protect Cakes by Linda. You're going to build up your value through making great cakes. But if it's culinary unicorn creations, my branding's obviously not my game, but if it's unique and it's something that you spend a lot of time and effort on, a lot of our clients come to us and think, well, I got the URL and I got the corporate name, so nobody else can use it. It's just not true. There's other things you can do. We're happy to point you to resources, or give us a call and we'll help you out with that. So we've come to the end of our time. We've got 2 minutes left. Is there anybody that has a burning question that wants to unmute themselves and ask it?
Hopefully you guys all have some kind of takeaway that's not super overwhelming. We really believe in prioritizing things. I don't think, Rome was built in a day. Isn't that what they say? So you do things gradually, prioritize the things that are most important to your business. If you don't have a large number of employees right now, that creating a handbook doesn't need to be your number one priority. So, and we're very candid about those things too. So if you ever, say, look, this is where I am, what do I need to worry about now? We'll tell you, this is what I would worry about now in 6 months, or in 5 employees, or whatever it is, this is what I would worry about. So we think that's a really good approach.
And just as parting words, we love St. Pete. We love small business. We love what we do. And we want to help folks like you stay in business. So even if you don't have a legal need that we can help you with, if you need another lawyer, if you need an accountant, if you need an insurance broker, we built up a lot of connections and can kind of help you cut through the chaff of finding the right person for your business. Or we'll tell you that we don't know them and put you in contact with somebody else. Or if you just need a sounding board for a business issue, you don't know if there's a legal issue, give us a call. We like having those conversations, and we've got some favorite stores and we want to see them stay around for a long time. There's some favorite businesses and favorite people. So please, one of the hashtags Meredith uses a lot is not jerks, because there's this perception out there that talking to lawyers is painful. We try not to do that. And please give us feedback if you ever think it is painful to say you lied to me and this should be easier. But please feel free to reach out to us anytime.
And follow us on social media. I put the links in the chat. So if you're not following us on Instagram and Facebook, you're really missing out on some awesome puns and hopefully helpful information too.
All right, everybody. Thanks so much for your time. We appreciate you taking an hour out of what I'm sure is a busy day. Please keep an eye out. We're going to send a survey asking for some feedback. I appreciate it if you answer it.
Thanks so much.
Thank you all.
Thank you.
Hey.
Have a great day.
Bye.
Take care.
Bye. See ya.